Everyone, and welcome to the Kansas Supreme Court. The court meets today in special session to consider case number 129788, Governor Laura Kelly in her official capacity versus Kansas Attorney General Kris Kobach in his official capacity. And a few of you may be unfamiliar with the court's process, so I'll just go over it very briefly. I would like to explain that all of the justices are familiar with the issues of the case, the parties' arguments, having read the briefs and those authority relied on in those briefs, and otherwise prepared for this morning's argument. We now look forward to the parties' oral arguments and our exchange with the attorneys. And one more thing, I want to remind counsel that the chair on the far left is not occupied because Justice Marla Lukert will not participate in the hearing today or in the discussion or resolution of the case. With that, will counsel please come to the lectern and your appearance, Mr. McAllister.
Mr. Chief Justice, and may it please the court, Stephen McAllister for Governor Laura Kelly. And with me at counsel table, I have Justin Witten, counsel, Ashley Stites, counsel, and in the first row, Emily Depew, all from the governor's office.
Thank you very much, Mr. McAllister. Mr. Kobach.
Thank you very much, Chief Justice Rosen. I am Kris Kobach, representing the Office of the Attorney General. We were just joking that I guess I'm pro se in this.
You know what they say about that.
Yeah, I do. Hopefully that doesn't apply. And with me are Dwight Carswell and Adam Steinhilber.
Thank you, Mr. Kobach.
Thank you.
One more, just the court met. Depending on the length of the argument, that opening argument, we may take a short break in between arguments, just depending on the length, and I can let you know. We'll determine that as we hear the arguments. Mr. McAllister, when you're ready, you may come to the lectern and begin your argument.
Thank you, Mr. Chief Justice, and may it please the court. With the court's indulgence, I would just like to take a brief moment to emphasize two fundamental points, and then I welcome any and all questions from the court.
And just to recall, you did reserve 10 minutes for rebuttal.
Yes.
Okay, thank you.
First, what is at stake here is that the governor is seeking to avoid the loss to Kansas and to Kansans of millions of dollars of funding that would support programs and projects that benefit Kansans and would also be pumped into the Kansas economy. Second, I want to be clear about the relief the governor seeks. I fear our briefs may not have always been completely clear in that respect, so I want to make that clear at the outset. What the governor seeks is a ruling from this court that her supreme executive authority includes the power to litigate to protect her executive interests. She is not seeking to represent the state of Kansas. That is the Attorney General's job. But she is the chief executive of the executive branch. She is charged by statute and constitutionally with administering a number of state agencies. And when those agencies are disrupted or threatened in their operations and litigation may be necessary, that is when she wants authority to litigate.
So can I just jump in really quickly and clarify? I understood you just now to say that all the governor seeks is the ability to litigate in her official capacity, in her name, and perhaps on behalf of the executive agencies that are under her authority. Is that correct?
That's correct.
So she does not seek ever
to name herself as the state of
that
Kansas.
She represents the sovereign, that is the political entity known as the state of Kansas.
That is correct.
And you're conceding that under our current constitutional structure and statutory scheme, that responsibility is exclusively dedicated to the Kansas Attorney General?
As the state, with, I guess I would add a caveat that under 75-108, she does have the authority to ask the Attorney General to take up matters, either defense or prosecution on behalf of the state. But what we are saying and recognizing is if he declines, which he often does, then she has the power, if it's in her executive interest, to go ahead and hire her own counsel and proceed with litigation.
But that is only litigation with respect to her as, in other words, this is a fight over who's the client, right? You're saying that even under that statute, if the attorney general declines, that her authority is limited to engaging in litigation in her own name under her official capacity and on behalf of her executive agency.
Yes,
Okay.
exactly.
And with that, let me tell you what my concern is. I understand the merits of the fight here. It's the procedural part, it's the posture of what's happened coming here. This is a quo warranto action, you know, by what authority do you do something? I'm afraid what's going on here is a battle of words between elected officials, and like we're being asked for an advisory opinion. One way to and that's what I want you to push back on. One way to characterize this case is, are you really trying to say that we should exercise quo warranto responsibility because the Attorney General filed an amicus brief in Massachusetts making legal arguments that you disagree with?
Not
That's
legal.
what it seems like.
Not legal arguments alone, Your Honor. Legal arguments that the governor has no authority or standing to participate in that proceeding. He is entitled to express a view as the Attorney General on the merits of a claim. So if he wants to argue why it's great that the federal government is terminating grants or seeking the private data of thousands of Kansas, he can make that argument. But what he's argued is that she can't be there.
But and legal disagreement, just a disagreement that you
over her authority. But again, if every time she files in her own name, she has to fight the battle with him coming in and saying she has no authority, there's only one court that can actually ultimately answer that question, and that's this one.
right, which is why I'm worried about the posture. I have no problem. And honestly, if the Attorney General really believes what they said, and we have to assume they did, they're officers of the court, they signed that pleading in Massachusetts. If they believe what they said in that pleading, I don't understand why they're also not in the Kansas courtroom to press that point, because there then the issues are really joined. For example, if what we're focused on is this amicus brief, and can't the federal judge figure this out on his or her own? You know, who's right? And if the judge really thinks there's some merit there, they could certify the question. So don't you have an adequate remedy at law for the fight the way it presently exists, as opposed to the way it's threatened to exist?
Well, I don't think it's adequate, Your Honor, because again, there are a lot of things happening and happening quickly here, which may require the governor to act. And what you're proposing, I don't disagree, might ultimately resolve the question, but it would take considerable time for that to occur. That is why we initiated this proceeding, because there's very real arguments. I mean, the Attorney General has taken active steps to try to prevent the governor. He has also informed her very clearly by letter in writing that if she tries to pursue things in her name as governor, he will try to stop her. So there's no doubt that this is a very real and live controversy. Might there be another way the issue could be resolved? Perhaps, but that's asking a lot to have everyone go to federal court and then try to get a federal court to certify to this court. This court doesn't have to accept a certified question. We'd like to resolve this now because it is this court ultimately that is the only one that can give a definitive answer.
But you're really asking us to resolve the threat and not some real action. That's what's.
Well, no, I think the real action is the Attorney General has stepped in already into this litigation and tried to say the governor cannot be here. That's a very live dispute. Maybe not in this court, but this is the court that can resolve the question whether he can do that or not.
And if he'd have asked us, then the fight's, in my view, clean. The quo warranto fight is clean. This is a little messy. The amicus brief in Massachusetts, where a federal judge can resolve the issue.
Well, I guess I'm a little unclear, Your Honor, on what more you want. Do you want us to file here before anything's happened in Massachusetts? I mean, that to me is what crystallizes the dispute. And then we come to this court as the entity that can answer the question far better than any federal court. And anything a federal court does is essentially advisory, because it's in, their best guess as to what Kansas law might be. This is the only body that can tell us for sure what Kansas law is, and that's the ruling we'd like to have. And not only because of pending litigation, but given the threat of the Attorney General that he will not, in essence, allow her, or he will seek to obstruct the governor in any efforts to represent herself in her own name.
Can I ask a few questions about that? I want to follow up on Justice Biles to try to determine whether there's actually a real dispute here. Exhibits 3 and 4, I think, are the letter from the Attorney General and the amicus brief that we're discussing, that were attached to your initial filing. Can you very specifically point to where in either of those exhibits the Attorney General seeks to prevent the governor from taking legal action in her own name? Because, and this is maybe highly technical, but as I read it, it looks like one way to read the amicus brief and this letter is that the Attorney General is saying to the governor, you do not have the authority to take legal action, quote, on behalf of the state.
He says that, but in at least one of the letters, he also says, nor do you have the authority in your own name as governor of Kansas. I
trust your
we can locate
representation
that for you, but in one of the letters, I agree, he says for the state, but he also says, and on your own behalf as governor of Kansas.
And I'll look for that as well, but if you find it,
we
I
will
would like
find
to
it.
see that.
Yes.
Thank you very much.
Yeah, and what I'd like to say about the issue here, there is, of course, a statutory part of this, but I want to focus first on the constitutional part, which is supreme executive. One of the arguments the Attorney General makes is that supreme executive is limited by the following clause, power to enforce the laws of the state. That is simply wrong. If you look at the history of that provision, the Kansas Constitutional Convention, they were borrowing from the Ohio Constitution. There were two separate provisions. Those things were not together. There was simply a supreme executive clause. There was another clause that has the reporting of the agencies and so forth, but also at the end it had a take care clause. The executive shall take care that the laws shall be faithfully executed. That's what they were adopting. It was a committee on phraseology, not the substantive drafting committees that put those in one, but even in one, it doesn't matter.
Well, is the term supreme executive power, is that without limitation? And if there are limitations, where do they come from?
Well,
the
limitations are inherent in the nature of executive power, and also they are determined to some extent by statute. So the supreme executive power means she is the highest official within the executive branch within her realm. But I'm going to define her realm. Her realm is not the Attorney General's role. Her realm is not the Secretary of State's role. It is not the Insurance Commissioner's role. Those have been treated separately and authorized separately by the legislature. But her role is things like KDHE and Department of Children and Families and Department of Agriculture, for which she is the chief executive. So she is supreme in those contexts. She has the power to appoint and remove. She's in charge of supervising, making sure those agencies fulfill their obligations and responsibilities. And that's what's at stake here. What's at stake here is threats to the operations of those entities that are clearly under her supreme executive power. She's not, again, we may not have been as clear as we could have been in the briefs. She's not seeking to put her name on a brief as the state of Kansas. She wants to put her name in litigation as the governor of Kansas, who is responsible for KDHE, who is responsible for the Secretary or for the Department of Agriculture. Those are the things she is supreme executive over. So, Your Honor, yes, there are limitations. It does not mean she can order the Attorney General around, does not mean she can order the Secretary of State around, does not mean she can order the Insurance Commissioner around.
And in that Massachusetts cases, correct me if I'm wrong, but it is my view of those pleadings was that the governor came in as a party in an amended complaint. And the allegation was that, she had the ability to sue in her official capacity as governor, as the administrator, which was in fact the same premise, I guess, as Governor Beshears and Governor Shapiro, because the other parts of the caption are a little different. So different governors come in through different approaches.
It might depend on their particular state laws, but yes, that is how she appeared. She did not purport to appear as the state of Kansas. I spent a lot of years in the Attorney General's office. We would file multi-state amicus briefs in the Supreme Court, for example. That is the state of Kansas. That's what the Attorney General does. She's not seeking that kind of litigation authority. She wants to be able to protect the supreme interest. So who enforces the laws of the state, that is describing one aspect of her duty. It's like in Article 2 of the U.S. Constitution that the president take care that the laws be faithfully executed. That's what that clause is about. It is not a limitation on her supreme executive authority, which is independent in Kansas, and it's independent in many other state constitutions. So that is where, at some point, when we talk about the statutes, there is the potential, if they are read too broadly, to preclude her from retaining her own counsel and proceeding in her own name. They would be unconstitutional. I don't think they have to be read that way.
Sorry, it sounded like maybe you're transitioning to your statutory arguments.
I'm happy to.
But before you did that, I wanted to talk a little bit more about how you define the Article 1 powers under our Constitution. Typically, we look for the intent at the time of original ratification, but in this instance, we have amendments in 1972 to two articles in particular, right? And do you believe that the historical background in 1972 and the period leading up to that is also relevant in ascertaining the intent?
Well, it certainly could be if it was intended to make any change in the supreme executive power. I don't know that it purported to, but it is the point we concede in a footnote, I think, that when Governor Docking proposed that the governor should be able to appoint all these officials, in essence, have a federal unitary sort of executive, that was rejected. That's not what we're arguing for. But I don't know if there's anything in 1972 that says, well, now your supreme executive power is less than it used to be. We're somehow limiting it.
The history I'm really honing in on is Governor Docking and other governors in the 1960s created these commissions to study these proposed amendments, right, in 1972 that ultimately came to fruition. In the background, as I understand it, there was sort of a national trend and debate about a unitary state executive, right? And a governor having the power to appoint and to remove cabinet members. And this commission that the governor put together generally agreed that some centralization is important for government efficiency. But the majority of that commission ultimately recommended that even though we're going to reduce the number of constitutional officers, we think it's important to retain an elected attorney general to serve as a check against government potential gubernatorial power. How, if at all, does that history affect your interpretation of?
In my view, Your Honor, not at all. We had an attorney general for a century before that. So it wasn't like they created an attorney general suddenly to limit the governor's power. They just wanted to retain a separate attorney general. So I think it's pretty much status quo, frankly. I don't think it changed anything. Instead, again, supreme executive power has its own meaning And it makes the most sense in the context of she is the chief over the agencies she is charged with supervising and administering.
Well, why would, I understand the litigation strategy, but why doesn't it mean more than that?
Well,
Why doesn't it mean supreme executive means I am, in a sense, the boss, quote unquote, of other constitutional officers?
it could, Your Honor, and we'd accept that if you want to go that direction. That's a harder argument, but there is some historical evidence for that view.
So if I could drill into that harder argument a little bit, because it gets at what I'm really after, which is something that's puzzled me in this case, and reading this court's prior struggles with a similar question, which is how are we to draw the line separating the powers and duties of different officers within one branch of government, within the executive branch? And I think that is a crucial question that, frankly, I've not seen anyone provide, including this court in our prior statements, a sort of a coherent explanation of that. Can you help with that?
Well, I'll take a shot. That is one of the challenges of state constitutions and divided executives. It's a much less straightforward, sometimes more messy system than a federal unitary executive. That said, I think to a great extent, it has been done by the Constitution, recognizing separate statewide elected officers. So they are recognized, they must have powers. And then legislative implementation, which by and large we don't argue with. So
Right.
the legislature says the Secretary of State has these responsibilities, the insurance commissioner has these.
I appreciate that where you're going, because that's kind of where I wanted to go. Just with my follow-up, which is, yes, that we can read in the Constitution, these are separate constitutional officers. They obviously have powers and duties. The Constitution says that. Article 1, Section 11 says the AG has powers and duties. I can only find two specific powers or duties outlined in the Constitution itself.
For the AG, that's correct.
And then there's nothing else. And our court has said, well, the legislature gets to define the powers and duties. That's, how can that be right? I guess is my question. I do see that in Article 1, Section 12, with respect to the lieutenant governor, the Constitution says duties as prescribed by law, which typically means the legislature gets to. There is no such provision with respect to the AG. So why does the legislature get to define the role of the attorney general?
That's a fair question. As a practical matter, they're the ones who've done it. And as I said, I spent many years in the Attorney General's office. There are statutes that we would have questioned the legislature's authority to control the Attorney General. I do think at some level with these officials, Attorney General and Governor especially, there are constitutional bases that the legislature cannot exceed. The challenge is figuring out where those lines are.
And that's what I wanted. And I know I'm asking a bunch of questions here, but if I could ask one more, do you think it's a coherent constitutional theory to posit that the office of Attorney General in the abstract had common law powers and duties at the time our Constitution was enacted, and that our Constitution essentially constitutionalized those common law duties?
You could take that view.
Do you agree with that view?
I have some wariness about that view, given that the Attorney General, if you're going to go back to English common law and so forth, was truly the agent of the Crown and subject to the control of the Crown, whereas that's not our system, and there is no more Crown in the American system. So the analogy to me is not perfect, but it may be helpful in the sense of generally, for example, the AG is in charge of criminal prosecutions, those kinds of things that wouldn't necessarily be controversial, but I wouldn't follow it necessarily 100%.
Thank you.
Sorry. In our case law about separation of powers, we talk about trying to identify where the problem is, and we use different terms. We use usurpation, intrusion, and significant interference are the three ones that I put on my list here. Do you think those are synonymous in this context? Or was the court moving the goalpost, if you will, moving from, usurpation, which sounds more forceful, to significant interference? See what
I
I'm saying?
mean, I see your point, Your Honor, and that certainly usurpation could be the strongest form there. Significant interference maybe is something lesser. I don't know that the court was necessarily trying to talk about different concepts. Certainly at the federal level, usurpation or aggrandizement, those are terms that get used as one branch stepping over the line into the prerogatives of another. This court has not really talked about aggrandizement. I think ultimately, though, the question is there have to be, and there are, certain core constitutional powers, granted, not always easily defined, but given to these officers. And whether it's the legislature or another executive officer who is trying to intrude or take away that power, that is a problem under the Constitution. So we would actually describe, if you want, take the strongest term, we would argue the Attorney General is trying to usurp the governor's litigation authority here. He is certainly significantly interfering with it. So I'm not sure in this case it would matter.
So now articulate how it's actually happening, as opposed to the saber rattling.
Well, it's the filing of the amicus telling a federal court she has no legal authority to be here. It's the writing of the letters saying if you try to pursue litigation in your name as governor, I will do everything within my power to stop you. That is a very real threat, I think, of perhaps more litigation initiated by the Attorney General's office, maybe instead of us. We, in a sense, are trying to get ahead of that. It's already started. So the dispute.
How does that interfere? I mean, she could just go do it and then have a fight about it.
Yes, but Your Honor, realistically, if you're a litigant in a case and you come in and you want to argue the merits of the case, and another, by status, the Attorney General litigant comes in and says, you can't even be here. Now, the federal court may disagree, but that is a tough way to have to litigate each and every case you may want to be involved in. It is fine, and we are not saying the Attorney General can't come in and say, I disagree with her on the merits of this federal law or this dispute. That happens all the time. But for him to come in and say she can't be here is a different kind of interference.
And the way this keeps going on in my head, though, is, okay, it's Massachusetts. It's an amicus brief. I didn't see anywhere in the pleadings where any of the real parties have taken up that argument. Not even sure that federal court's going to take it seriously. But again, if they do take it seriously, either the court can decide it, and there you are, or they can certify a question and get it to us, and then it's a real clean dispute.
Well, I don't
For
see
our purposes, I'm really worried about this, whether you're pushing us over to advisory opinion land.
No, I hear you, but I think it is a very real and genuine dispute. And I think what you're suggesting is a way the dispute could be prolonged. We're preferring that it would be settled sooner. But I don't see how, if the court in Massachusetts takes it up and gives this court a certified question, how it's any more real then than it is right now. I mean, we know the same facts already that we know now about what's going on in this situation between these two officials.
Before you sit down, there's some real basic concepts here that I'm having trouble identifying either in the Constitution or in the statutes. And a real basic one is, and I want to give you an opportunity to weigh in, I want Mr. Kobach to do the same, is where in the Constitution gives you authority or anyone authority to decide what is in the interest of the state? Who makes that basic? Can both entities make that determination? And also, what is clearly adverse to the legal position identified to the state interest? I'm having trouble tying those into concepts presented by both.
Well, I think in terms of who decides the interests of the state, it's the bodies that are charged by the people through the Constitution with making those decisions, that is not one single entity or official. So, I mean, certainly the legislature has some role in defining the interests of the state. The governor within her sphere has a role. The attorney general within his sphere may have a role. The secretary of state within his role may have, or within his sphere may have a role. That's the nature of a state constitution. And that's one of the challenges. I agree.
It is a challenge.
Because there is no client. We can simply go
Right.
walk across the hall and say, what is your position on this state of Kansas? There's not that kind of.
And I would say your client believes that the Attorney General has taken a position that's clearly clearly adverse to the state's interest.
And I would say
that's kind of your lever to get into court, isn't it?
yes, well, partly, but maybe you're sort of talking at least, or I'm going to talk about 75-108.
Right.
That last clause. So a couple things I wanted to say about 75-108 that I'll do briefly. It does say that the governor, he or she may, if the public interests require it, employ counsel. It also says if the attorney general shall be in any way interested adversely to the state, she also can employ counsel. I think those under the statute have to be left to her discretion as governor to make those judgments.
Thank you.
Yeah.
To how you started out your argument, and I'll be curious to hear if your colleague is as surprised as I am to hear the reframing of what I think we understood the issue as presented in the briefing. Certainly the position seemed clear. It's prayer for relief asks for a declaration that, and I'm reading from paragraph 55, a declaration that if the Attorney General, can you hear me?
I can.
If the Attorney General makes himself absent by declining or refusing the governor's request, she may retain counsel under KSA 75-108 to sue and litigate actions on behalf of Kansas. Are we to understand that that's not the relief you're requesting? That harder question. I mean, I think you're trying to make this an easier question for us. But I think there's a harder question here that's presented by what's going on.
Well, I don't think it has to be presented. I think it would be one way to answer the question if she does have the authority to represent the state, but actually that may be inartfully phrased on behalf of Kansas. It probably would have been better stated as on behalf of the interests of Kansas and her role as governor. So she clearly has authority as governor to make decisions that she believes are in the interest of Kansas in fulfilling her executive responsibilities. I think if you go back to paragraph 53 in the petition, it's more consistent with what I'm saying this morning. So that I think we articulated. She wants to be able to sue in her name as governor of Kansas, protect her executive interests. The bigger bite would get us where we need to be. It would certainly give her the freedom to litigate. But I think that's a harder question. As I talked with Justice Stegall about, we can make some arguments for it. They're there in our brief, but I don't think the court needs to go that far to say, for example, she can order the attorney general to do something that he refuses to do. She might have some authority there. Certainly both statutes and the Dawson case suggest that. Some history suggests that, but we don't need to go that far in order to resolve this dispute.
Thank you.
So I'm gonna, oh, sorry. I that brings some follow-up questions to my mind, because I do think, and I'm sure you agree, that nailing this issue of what the governor is requesting is really important to help us decide this case. I had thought you were pretty clear at the beginning of your argument. Just now, you seemed a little less clear. which
Well,
makes me,
I'm trying to say the same thing, but tell
and I
me,
appreciate
help
that.
me with the,
So there's a difference in my mind between saying we are not asking for X, and in fact, we concede that we can't get X. There's a difference between doing that and saying we don't need to ask for X to win. We can just ask for Y and we still win. But X might still be on the table. And that's the answer I just heard you give. Whereas at the beginning, when I said, for example, are you effectively, you are not requesting relief to represent the state of Kansas. And then you went so far, I think, when I asked as to concede that only the Attorney General under our current legal structure and statutory scheme has the authority to represent, quote, the state of Kansas. So
and
I'm kind of like, which is it?
the first is what I intended, Your Honor. So we do say you don't need to. We don't ask you to decide that bigger, harder question. All I'm suggesting is there are historical arguments that might support that position. We talked about some of them in our briefs, but we are not today asking the court to do that.
And are you indeed conceding that only the Attorney General can act as the legal representative of the entity known as the state of Kansas?
Only the Attorney General can act as the legal representative. The historical question is more to what extent might the governor compel him to actually step up and do that? Because even in the Dawson case, the governor was not talking about stepping in as the state.
Right.
It was about whether the governor could require the attorney.
And I think
general.
you said that you don't take issue with the fact that the Attorney General may refuse that request when it's given.
He does it regularly.
Okay.
Yep.
Thank you.
And just moving on to one more statute, 75703. I understand, there's a larger question about whether any of the statutes may infringe on Article 1 powers, but setting that aside, what does 75703 do? Because on its surface, one might take the position that that statute, the legislators asking the Attorney General to serve as the representative for the governor and those agencies, which sounds very similar to the role that you've tried to carve out.
And you could take that view, and certainly that could be applicable here in the situation where we're losing grant money that is attached to and funds all sorts of contracts that are implicated with the agencies she supervises. So that is why we pointed to 75703. This particular litigation does have impacts on contracts and potential financial obligations of the agencies she supervises. That might not be true in other circumstances, but here it could be.
But is the legislature carving out a role uniquely for the Attorney General under that statute to occupy that sort of?
Oh, I don't think the point is you get to occupy the whole territory and decide whether or not. No, I think it would be that the governor, if you really want to apply that statute, the governor could compel him to step up and defend and represent the interests she's asserting. So then we might be back to Dawson, I suppose.
That prompted, reminded me of something. I'm not going to be able to cite the statute that sets up the authority of the secretary, and that's cited kind of by both of you. Nobody bothered to cite subsection K of that scheme, where the legislature said the secretary can sue and be sued. And I wondered, does that section apply to this controversy?
Well,
For some reason that didn't happen, because that's very typical language across
right.
all of our statutes.
It is, and that happens with some regularity. So there's certainly cases in which the Attorney General is asked, would you represent this agency? No. So the agency gets its own counsel and proceeds. But the irony and the irony of the result that I understand the Attorney General to be seeking is he's quite happy to say, no, KDHE, go defend yourself. But if the governor, who's in charge of KDHE, wants to try to defend KDHE, he's saying she can't do it. And that really makes no sense under a constitutional system in which she is the supreme executive. Why can a subordinate go find legal counsel, but the governor herself cannot do that. So that's the problem I have with that. But it is certainly not an uncommon thing that the Attorney General's office, one, says, no, thank you. Go get your own counsel if you want, or two, even sues the agencies himself sometimes. So they have to defend themselves against lawsuit by the Attorney General.
Any other questions of Mr. McAllister? Thank you very much. And I note
Yep.
that you reserved 10 minutes. Mr. Kobach.
Thank you, Mr. Chief Justice, and may it please the court. I want to begin with one really small point, and then I'll return to it later, and that is the opposing counsel is asking this court to erase a definition that this court has already given to the phrase supreme executive power. And that definition was given in Stubbs v. Dawson, 86 Can at page 180. I apologize for our briefs not emphasizing that clearly enough. There is already a definition, and I'll come back to that. But the second thing, which I think is on everybody's mind, opening observation, is that the governor's position continues to change dramatically through this legislation. Justice Walsh asked, and I had pulled it out myself, the relief sought, paragraphs 53, 54, and 55. My impression is, we started this briefing assuming they were asking for all three things. Then they dropped, as of their latest brief, they dropped 54. 54 says that the governor has the authority to direct the attorney general to sue. Became clear they had dropped that one. But now today, I think the opposing counsel has dropped 55 too, 55 as well, which is the a declaration that the governor may sue and litigate actions on behalf of Kansas. In other words, on behalf of the sovereign. So I think they're down to only seeking the relief in paragraph 53. But even paragraph 53 has a lot to it. A declaration that the governor has the constitutional authority to sue on behalf of her office and the interests of Kansas. Once you add "and the interests of Kansas," then you're talking about everything. And so
what is that phrase? I mean, that's been bandied about by both sides here. And I mean, we're all lawyers here, and interests are not a client, right?
That's exactly.
What is that? So does that have any real meaning, or is it kind of boilerplate puffery?
I think it has no real meaning. And what it means is, if any attorney walks up and says, I'm suing on behalf of the interests of Kansas, which is what the governor is claiming the authority to do, and now she's narrowed it, I think, to executive interests, and I'm not sure if that phrase has any concrete meaning either, then she's basically saying, I'm suing on behalf of Kansas, but I'm not suing in the name of Kansas.
Only entities can have interests, right?
Correct.
So what this fight really is about is what I mentioned to your opposing counsel, which is, who is the client? And once we answer that question, and it sounds like the parties may actually not disagree on that question anymore. If that's true, I mean, the interest question really isn't for us to decide. The question is, who's the client? And if the client is only the governor in her own name, her own official capacity, and the executive agencies, which she is, which she has authority over by law, if those are the clients that she is seeking to represent, well, you wouldn't have a problem with that, would you? Or maybe you would.
Actually, no, I wouldn't, Your Honor. And that gets to the final position they've retreated to. It's still kind of unclear. I'm hearing two different definitions. If they're retreating to the position, she still can sue on behalf of her office, then we are in 100% agreement. And that's what she's doing today. She's suing on behalf of her office. But the phrase that opposing counsel used was, no, she can still sue on behalf of her executive interests. What are executive interests? That's the whole waterfront.
Well,
anything any agency does is within that agency's executive interest. Government agencies do everything.
Would you agree with me that determining the interests of a client in any particular piece of litigation is up to that client? I mean, they can articulate their interests however they want. You know, the KDH&E can say, our interests, we believe, is on behalf of the Kansans we serve, and we think that it's XYZ. That doesn't mean that they're setting the legal position as to the legal position of the state of Kansas. I understood opposing counsel to say that's reserved to the attorney general.
But perhaps we could phrase it this way, Your Honor. KDH&E could say, we have an interest in protecting the Earth's atmosphere and the climate of the Earth. That is one of our interests. And so we seek to sue whatever federal administration is in power because they are taking actions that are impeding our mission to protect Kansas' environment and the climate. So that's the problem. Executive interest goes too far still. If you're
Why
talking,
can't they do that? I mean, it may be a frivolous lawsuit that they'll lose, but why can't an executive agency exclusively under the authority of the governor take whatever legal position or action that they want to?
because at that point, Your Honor, they are advocating on behalf of the interests of Kansas. They're taking something so general. It's not limited to the powers of their office. It's about the general interests of the people of Kansas, and that's treading upon the Attorney General's authority. If we're arguing something broadly about what
We have to really get into the merits of what I'm trying to do is keep it simple, which is focus on the
Yeah.
client. But it sounds like both parties want us to get into the merits of the substantive claims made before we can decide who the legally authorized lawyer is. And that strikes me as, from a judicial perspective, unmanageable. It's an unworkable standard.
We are not asking you to get into the merits of, we are asking you to take a very simple and very constrained role of the governor's authority. And that is, she may only litigate on behalf of the powers and the prerogatives and the scope of her office, not on the things her office would like to do in the world, but just the power.
So it's just the magic words, interests of Kansas.
Right.
That you object to.
Yeah, we object to this word interest, which is.
And we're,
Is there, you have the power to decide that, right?
Right.
Actually, this court has said that I have the power to decide that. It goes back to the Finch case, Your Honor.
No,
In Finch,
master of the universe. Let me
in court, Your Honor, in court.
understand that.
Finch said that,
Okay, let me give you a hypothetical. Let's assume the Department of Justice sues the Secretary of the Department of Children and Families in federal court over this SNAP business. Are you saying that you have the power as Attorney General to go into that courtroom and confess judgment?
that one, I guess, classic attorney answer, it depends. But I think
What
in
does it
that,
depend on? Because
it depends on the
you
case.
guys have both bantied around this interests of the state thing, and that's the black hole here. She sued in Massachusetts in her official capacity as governor, and you said she can't do that.
Mhm.
So to take my hypothetical, what does it depend on? I thought you decided what was in the legal interest of Kansans,
And that's where I'm
and
going.
so you can come in and wipe away that lawsuit just by confessing judgment because you believe it's right.
The reason I said it depends, it depends. If you're talking about the current dispute about the SNAP payments, I would say that the Attorney General has the authority to come in and say, Kansas law obligates us to give the requested information to the federal Department of Agriculture. As a result, our position is that we have to abide by Kansas law, and the agency may or may not have made certain errors and may have been out of compliance with state law. And that's indeed what we argued in Shawnee County District Court.
Well, that was a mandamus action. That
Yes.
wasn't
Yeah,
over this authority thing.
right.
And just so I'm right, that was dismissed and you didn't appeal.
As not ripe, correct. And we decided to wait until things progressed before.
I still get back to, if the secretary wants to fight that fight with the Department of Justice, why can't the secretary do that?
Because this court has recognized that the Attorney General controls the advocacy of the state's legal interests in all courts. And so, and the Finch case is really instructive, and it's amazingly broad when you read it. And I'll get into some of the, I can get into it right now.
Before you get into that, where in the Constitution does it, same thing I asked Mr. McAllister, where in the Constitution does it give you the sole authority to decide what is in the interest of the state?
I would argue, Your Honor, by use of the term Attorney General, which a term that has been around since the 15th century. And the Attorney General, this is what the court in Finch explained, the Attorney General comes into the Constitution as a term laden with meaning. And so the Attorney General is presumed to have all of these authorities, not those authorities, but the Attorney General has all of this meaning. And then Finch added, the legislature may subtract or modify all of those powers inherent in the term Attorney General. But this is what it comes in with. And now the legislature can mold that clay and change it. But the term Attorney General implies, or not only according to this court, more than implies, the term Attorney General includes the ability to define the state's interests. And I can, if you'd like me to point you to a specific provision.
While you're looking at that, a couple questions about Finch, and I asked your opposing counsel similar questions. This is sort of the idea that our Constitution cemented in place the common law powers of the quote Attorney General.
Yeah.
And I understand that. Whether or not it's right or not, I guess remains to be seen, but I can understand that. Sort of like how we treat our Section 5 jurisprudence. You know, the common law right to a jury trial was constitutionalized at the time of ratification. What I don't understand, or I want you to help me understand if you can, is this idea in Finch that the legislature gets to change it after the fact. Because if the constitutional theory is that the Constitution cemented in constitutional law what was previously common law, how does the legislature get to just change that after the fact?
You know, I think that's a great question. And I think the answer probably is the basic thing we learn as lawyers, that the common law exists everywhere in the United States until the legislature modifies it. And so I think there is this sense that the legislature always has the power to
and that's generally true, but if I stick with my Section 5 analogy, that is not the case.
You're absolutely
clearly said, and it makes sense that if you constitutionalize common law,
right,
the legislature no longer has the ability to statutorily modify it.
I agree. And in principle, you're absolutely right. I think the term Attorney General contains so much meaning in it that that maybe in that one that you would say, wow, there's a lot here. The legislature might have to say, of these 20 things, only 19 are included in Kansas.
Which position are you taking today, if any?
I'm going to stick with the even though it's constitutionally problematic, I'm going to stick with this court's precedents, and that is that the common law powers of the Attorney General are the ones he has.
So you think that the legislature, if it desired to, could pass a statute that simply said the legislature shall have no powers other than the power to remove county sheriffs in Article 9, Section 5, and the power to file reapportionment?
You think that? You mean the Attorney General shall have no power?
Right.
Yeah.
Yes, I'm sorry.
Yes, I agree. The legislature could do that.
Okay.
They cannot remove the Attorney General's office from existence because that's in the Constitution, but they could take away all of our power and give it to the governor.
If that's the case, then doesn't Finch not support what you're saying? Because the quote from Finch is the Attorney General's powers are as broad as the common law and less restricted or modified by statute.
I think that's exactly what I'm saying, Your Honor, is that the Attorney General's powers in the Constitution are as broad as the common law understanding of the Attorney General, but the legislature can come in subsequently and modify it. So if they wanted to, they could come and erase 90% of it.
But doesn't 75-108 modify it?
Right, and the legislature can pass 75-108. We're not disagreeing with the validity of 108. We disagree with the meaning of 75-108. And I'll get to that.
You want to go into that?
Okay, can I finish answering
Oh, sure.
this one, and then I'll go to 75-108. Okay, so Mr. Chief Justice, the point in Finch that I was pointing to is on page, and then I'll go to 108 after that, Your Honor, is on page 912. And it says, quote, as the representative of the state, an Attorney General is empowered to bring any action which he deems to be necessary for the protection of the public interest. And as a rule, the Attorney General has the power both under common law and by statute to make any disposition of the state's litigation that he deems for its best interest. For instance, he may abandon, discontinue, dismiss, or compromise it, end quote. Again, that's at page 912. So I think this court has recognized that it is the Attorney General who gets to define what the state's interest is in any litigation.
No, go ahead.
Okay.
Sorry, we're bouncing you around all over the place. I apologize. But now I'm losing sight maybe of the larger picture in the developments today. Let me just try and keep that fresh in my mind at least. And I'm thinking of two different concepts, one being party status or capacity, and the second being standing. And it sounded like today you were in agreement in terms of the governor having is recognized as a legal entity that has capacity to sue or be sued in their official capacity, right?
Yes.
Okay. But the question about whether they have an interest, is that simply dealt with on a case-by-case basis with a standing analysis or a justiciability analysis?
I think the standing analysis would be a little different, Your Honor, because there you'd be asking for an injury in fact, and you'd be assessing questions of remediability and whatnot. But I do think that here we can, if I'm understanding your question, I think we can say this is a little different here, and that the governor can be certainly a party. She can be a defendant all day long, and she is a defendant quite often. And usually the attorney general steps in because it's a collection of defendants, and the attorney general leads the defense. But as a plaintiff, she has to step forward only representing her office and not the interests that she has as the chief executive of the state, but her office. And we would heartily agree. And she, of course, in any case, she can, as an individual, file an amicus brief. All of us can file amicus briefs. So she could do that as long as she made clear it was not on behalf of Kansas or, the interests of Kansas.
But why can't she file a lawsuit in her official capacity as governor over legal matters that are affecting programs that are statutorily set up to be operated by the executive branch, by the governor, by the secretaries? That just seems logical to me.
Well,
as opposed to giving the attorney general the ability to just decide whether that affects the legal interests of Kansans, and you alone control that.
well, that's why I say she could certainly file an amicus brief saying, as governor, my office, or she, in her personal capacity.
I don't understand. Where does it say she can file an amicus brief?
Because once she's representing, she steps in as a party, or attempts to step in as a party, she is representing Kansas. She's litigating on behalf of Kansas. She can say, no, it's not Kansas. It's the interests of the executive branch of Kansas. But that's a distinction without a difference, Your Honor.
We've got statutes littered with the phrase that so-and-so or this entity can sue or be sued. That tells me the legislature recognized that there might be litigation against this entity or this official, and they're giving them the capacity to sue and be sued. By definition, the interests of Kansas, the legal interests, are involved in that. And it seems to me you're saying you get to step in and take over that litigation and control the outcome, regardless of what the agency said.
Well,
the Kansas Turnpike or anything else. All these entities have the capacity to sue and be sued.
Well, Your Honor,
I don't see where it says that can be overridden by your analysis as to whether it's a good case or a bad case.
Your Honor, it says it in 75-702. Quote, the Attorney General shall appear for the state and prosecute and defend any and all actions and proceedings in which the state shall be interested or a party, and shall, when so appearing, control, your word, control the state's prosecution or defense, end quote. The legislature gave the Attorney General that power. Now, opposing counsel has argued that perhaps that is unconstitutional, and that runs into supreme executive power. And I think that's where the really interesting argument is here, is that there's no question the legislature gave us this authority, the office, this authority. The question is, could they do it and trench upon the meaning of supreme executive power?
A different way to resolve that conundrum might be that the legislature understood that the state is not the same thing as a subdivision of the state. It strikes me that your argument sort of views the subdivisions like a nesting doll, and the state as an entity subsumes all its subdivisions. But there's a different theory of government, which is subdivisions have their own legal standing independent of the legal standing of the sovereign, the state.
I would say, Your Honor, typically most litigation isn't constructed that way, though. When the state is a defendant, it will be, we sue Governor Kelly, we sue the Department of You name the Department of Transportation, and we sue this Secretary of the Department of Transportation. And in effect, and what they're actually doing is they're challenging a state statute that the legislature has passed. And so they're suing a bunch of entities in the state, and the Attorney General has and must and should step in and say, okay, we will defend everybody here. And so I think it is like a nesting doll.
I mean, your argument is or not.
Well, no, I do believe though,
You get to say whether the defense has any merit, and if it doesn't have any merit, you just surrender.
no, I don't think the Attorney General has the, there is it's not in our Constitution, but there's a traditional duty of the Attorney General to defend all state statutes. And I think when it comes to a statutory challenge, the Attorney General absolutely has an obligation to defend.
Well,
I mean, when I was in the Attorney General's office, we sued lots of times about the constitutionality of a statute and said it was unconstitutional. And we won a few of them. So, I mean, each Attorney General is going to view how they want to perform their functions. Some are more defensive of what the legislature does. Others are not. I just don't see where that's discretion becomes control. I mean, to me, this case is a lot like the Vern Miller versus Marion School District, the old Peabody case, arguing over who has authority over local school districts or the State Board of Education or the legislature. And in the end, the Supreme Court said the people have given a lot of authority over this subject to a lot of different groups. It may be messy at times, but y'all sort it out. There's not any one supreme commander in effect.
I would just say that, in 2013, the legislature came in and passed 75-702 and appeared to maybe try to clean up some of that messiness. If they did so unconstitutionally, that would be a question for this court. I still have your question about 108 that I want to answer. But I think right now I want to make one more constitutional point and then jump to that. And that is, this court already defined the constitutional text supreme executive power back in 1911. The Dawson Court itself defined the term, and I'll just read the two sentences. Quote, perhaps the term itself, taken in connection with the context, is sufficiently explicit. An executive department is created, consisting of a governor and the other officers named, and he is designated as the one having the supreme executive power. That is, the highest authority in that department. End quote. 86 Can 180. I think that's the most important thing I can leave you with today. If it's constitutional, the constitutionality of 75-702 is at issue. This court already defined supreme executive power, and it did so in, I think, a way that's truly ingenious, because you have what we've been talking about, the legislature's authority to go in and treat the executive branch like a Lego set and reassemble and change and take power from the governor, give it to the Attorney General, take power from the Attorney General, give it to the Secretary of State. So what this court did in Dawson is said, well, what it means, where it's supreme, is when the legislature does use its Lego set to create a new executive department, the governor has to be supreme in that department. And so that's what supreme executive power means. And so this definition recognizes the authority, the incredible authority of the legislature to reorganize the executive branch. Our Constitution does not recognize that the executive can reorganize the legislative branch, but the legislature has that authority. And it's a big one. And in many ways, it reflects the federal Constitution as well. And I could just...
Another quote from Dawson is, the court found it clear that the phrase supreme executive power is more than a verbal adornment of the office and implies such power as will secure an efficient execution of the laws in the manner and by the methods and within the limitations prescribed by the Constitution and statutes enacted in harmony with that instrument.
Exactly, Your Honor. And take it in context, here's where that quote is going. There were two laws at issue in Dawson, and the Attorney General the question was he following those two laws? And the governor was saying, you're not, I'm ordering you to follow them. One of them was the early version of 75-702, but the other one was General Statute 1909, Section 4366. And here's the quote. If the Attorney General shall be notified, it shall be his duty forthwith diligently to inquire into the facts of such violation. End quote. It was about violations of the prohibition laws of the time. And that case was all about prohibition. And the attorney general was saying, I already talked to the guy. I don't need to do a formal subpoena of this person and witness him. I know I have all I think I need to know. The governor was saying, no, you have a statutory obligation to do more than that. And therefore, I, the governor, am pushing you to obey the statute. So that's what I think when this court said it's more than a verbal adornment. This court was saying, we can tell you have to follow the law. And that was the law at issue in Dawson. Let me just quickly touch on the legislature's constitutional authority to reorganize the executive branch. I think everybody here is familiar with it, but I think the best quote is from 1973 in Van Sickle versus Shanahan. This court said, quote, the legislature has constitutional authority to organize or reorganize the executive branch and assign functions to it on terms of its own choosing, end quote. That's 212 Can at 448. And then we've already mentioned how in Finch, this court said, we conclude that the attorney general's powers are as broad as the common law unless restricted or modified by statute, end quote. And so
that kind of goes to the interaction between the two laws here, which is 75-702 and 75-108.
Right.
And how do you believe those two laws should be read together?
Okay, and that's exactly where I was going, Your Honor. Thank you. So first, I've mentioned 75-702, and as I pointed out earlier, I believe that it gives the attorney general control of the litigation, and the word control is used in the statute whenever the state's interests are involved in court in any case, and the attorney general can control the case. Now, then the opposing counsel would say, and you might be suggesting, Your Honor, well, what about 75-108? Which says that the governor shall inform the attorney general of a proceeding and ask the attorney general to act in conjunction with the counsel of the proper party to protect the interests of the state.
Okay, well, what I would like to do is split, that's kind of a long statute. I mean, it's a very long
Yes, it is.
Paragraph right there, and split it into three parts. Okay, so the first part identifies this triggering event, the commencement of any action. But then the second clause allows, and I guess there's some ambiguous. Oh, sorry, Siri wants me to try again. So the second clause, and there's some ambiguity in he or she to employ counsel when public interest requires. And so there's ambiguity with those pronouns. But what I'd like to focus on is the third clause, that the governor can hire counsel if the attorney general is unavailable or quote unquote, interested adversely to the state. So I'd like to know, what independent work does the phrase interested adversely to the state do? I know in your brief, you said, well, that means an ethical conflict under the Kansas professional rules of conduct. Is that right, what you're arguing?
Yes, and it's not just this is something another court has recognized with the same words in another state, which I could talk about too. Yeah, we think that the interested adversely is nothing more than conflict of interest. And that exact question.
Well, why would the legislature have added that if it really means nothing, given the rules of professional conduct?
Well, no, they added it because they're saying if the attorney general is conflicted out, the governor has the ability to put someone in. And I think we need to really understand 108 in context. 75-108 was drafted and enacted in 1861, and then it was amended in 1879. And it's been pretty much the same ever since then. We did a little research on this, and we mentioned it in passing in our briefs, but I can give you the exact number right now. So from 1861 all the way well into the 1880s, any idea how many how many attorneys there were in the attorney general's office? One. The attorney general. Then at some point in the 1880s, early 1890s, it went up to two, an attorney general and one assistant. And then 1894, the report of the attorney general complains, and he says, two is not enough. We need a third attorney. That's nothing compared to the 60 attorneys approximately that the attorney general's office has today. But that makes 75-108 perfectly clear in context. If the one person who represents the state in court is sick or absent or conflicted out, the governor can employ someone and we agree, it could, he or she could be the governor. The governor can employ someone to act in his stead. This is about a frontier state barely able to provide one attorney to appear in the various cases where the state is interested. And it is simply providing a way to substitute for the one attorney that the state of Kansas has. It is not the opposite, which the other side is trying to draw meaning from these words. They're saying, oh no, you can have duplicative attorneys everywhere. We can have the governor representing her executive interests. We can have the attorney general on behalf of the state of Kansas. No, it was about filling a void where there was only one attorney.
Where do you get that? How do you reach it? Interests adversely to the state seems to imply to me a broader determination and an important determination other than just a conflict or absence from the case.
Yeah.
And that, to me, I don't see where that authority lies with you in the constitutionally anyway, or with the governor. Who gets to determine that?
Well, I think it's the same. The answer would be the same. Who determines what a conflict of interest is?
Say conflict of interest.
Well, here's where the answer I was gonna give you earlier, Your Honor. The Illinois Supreme Court interpreted virtually identical language in its constitution in EPA versus Pollution Control Board, and we do cite this in our brief on page 12 of our November 17th brief. And the site is 69 Ill 394. That was a 1977 decision, and said, yes, that refers to, they phrased it the same way and said that's conflict of interest. And it makes sense because it's right alongside sickness and absence.
But shouldn't it be read in light of the statute's purpose, which is really to protect state interests?
Sure. And if an attorney is conflicted out, you got to have somebody step in and represent the state's interests. This statute is an 1861 statute that's all about making sure there's somebody in court representing Kansas. And it also recognizes that the governor can point to the attorney general in this frontier state with no telephones and no internet and say, Mr. Attorney General, there's something that happened out in Wabaunsee County, and we need you to go investigate and represent the state there. Attorney General says, I don't have time. That's where it says he may employ other counsel to assist the Attorney General, not to.
That's in the second. That's in the second,
right? But you read it all together, as we must with these statutes. It's all about finding people to represent the state when there was one person in the Attorney General's office. And so I think it is a statute that still has some meaning, but it's the context makes clear. It's all about just making sure somebody goes to court. Now, if I'm sick, one of these guys steps up. If I'm conflicted out, depending on the nature of the conflict, we have a private law firm do it, or if it's a sufficiently narrow conflict, maybe somebody else in the agency can do it.
This is really just the bedrock almost of this case if we get to the statutes. And you and the governor have different definitions, and we say that it's, ambiguous because you say it's, Kansas rules of professional conduct, and they're saying that, if the executive agencies, to protect them, what is there in any kind of legislative history, going back to the 1800s that make you think that it's an ethical, beyond the fact that, you're saying there was one person.
Well, Your Honor, our points about the ethical conduct were back at the beginning of this litigation when we thought their position was that that the governor gets to order the attorney general to litigate in a case. And there is a very clear precedent from this court saying that it is an ethical matter, and the governor cannot order the attorney general to argue something he doesn't want to. And that is in it's in Foster and it's in Morrison v. Sebelius. The Foster court said, based on the constitutional separation of powers, the attorney general, and I'd never read this until I reread the Foster case. The attorney general is a member of the judicial branch. Did you know that? I guess a quasi-judicial, quasi-executive official. And so the Foster court says, because the attorney general is an officer of the court and a member of the judicial branch, and here, let me read the quote. Since the attorney general is an officer of the judicial branch, under the separation of powers of the three branches of government, he was limited and restricted in his conduct before this court by the Code of Professional Ethics. If, therefore, the attorney general considered the action unmeritorious, he had not only the authority, but also had a duty to move for dismissal.
That's under the first clause, though. We're talking about the third clause that talks about, I'm talking about that you're saying that third clause.
Oh, I'm sorry. I was jumping to the other references to ethics in the constitutional argument, where this court has said that there's a.
Right, I'm
Okay, you're
focusing
still
on the
back at
third clause.
108. Okay.
75-108.
Okay.
The adverse interest, and whether that would reasonably include where the Attorney General has taken a clear legal position aligned with an opposing party and contrary to identified interests, in this case of the governor, related to the agencies.
Your Honor, I'd add one more thing here, and I'm going to get into the grammar of it. If he or she shall be in any way interested adversely to the state, and that is a statement of he is in a, it's not a if he wants to be or he believes something different.
Right, that's what, did you hear my question? So why wouldn't it be reasonable to conclude where the Attorney General takes a clear legal position? So here, filing the request for mandamus and also filing an amicus opposing the governor, aligned with the opposing party and contrary to the governor's interest in, her executive agencies.
Because in that position, the Attorney General I am saying the interests of the state, we don't agree with the assessment of the interests of the state that the governor has.
So it comes down to what is the definition, as we said before, of what is, I think Justice Stiegel, what is the definition of the interest of the state?
Which is why, Your Honor, and I am answering your question, that last phrase in 75-108 says shall be in any way interested adversely. In a state of being interested adversely is not, I think I've taken a position that other people, my will is to do something that's against the interest of Kansas. No, it's a shall be. It's an objectively defined, you are in a position interested adversely. You've represented a party that has sued the state on a similar question. You are interested adversely. That's why I think it has to be read, just the grammar of the sentence as conflict of interest. It's the word conflict of interest is not something that, the term interest in conflict of interest is very different than the term interest in the state's interests. And I think
it's like, just to be very simple, it's like if you're, or the Attorney General is a big shareholder in a corporation that has allegedly committed a crime. I mean, there's a clear, that's what you're saying.
That's what I'm saying.
That
you are interested adversely.
You're interested adversely because if the state wins, you're going to lose a lot of money.
Right.
Or something like that.
We use the phrase conflict of interest today. Back then in 1861, they said interested adversely.
But when you believe that the administrative agency is legal argument that they need to make or want to make is without merit, there's no conflict because you win. That's the way you're interpreting your authority as Attorney General. You get to decide what legal arguments, even the network of the governor's offices or these separate entities that have the power to sue and be sued, you get to decide what the meritorious legal argument is in their operation. That's what I'm hearing from you.
Well, then I apologize, Your Honor. That's not what I'm saying.
What's the limitation?
What I'm saying is we will defend and do defend and have an obligation to defend all of these agencies. And that's where 75-703 comes in, which was mentioned earlier. The only stopping point there is when the agency's action is in clear violation of state statute, because I also have a parallel obligation.
I mean, people can have a different view. I'm just
Right.
saying that when you decide that, you win.
Right, but some statutes are very clear. And when it is clear that the department is violating state statute, and I mean very clear, not gray area could be, but it's clearly going against the law, then I think the Attorney General has a much higher obligation to defend state law than to defend an agency action.
There's nothing to defend because they don't get to represent their viewpoint that you're wrong because your position is you control the litigation. You get to say, well, I win.
No, I think a perfect example of this was the driver's license case of which this court recently declined to review of 2023. There, the new statute said that the that all agencies that track vital statistics shall define sex as biological sex at birth. And the governor's agency said, well, we think that means we can have it in our database, but we don't need to put it on the license. So we track it, we identify people that way, but we don't actually put it on the license. We said, the Attorney General's office issued an opinion and then litigated and said, no, the statute means it's on the license too. The agents in that action, which was a mandamus action, the agency was able to come forward and say, no, the Attorney General is wrong. You can interpret these words differently than he does.
What I don't understand is why isn't that a usurpation of the authority you're claiming as Attorney General?
Because
you're supposed to control what happens in the appellate courts.
I do not assert that the Attorney General controls the meaning of all state statutes. Whenever there is a dispute between the Attorney General and a state agency about the meaning of a statute, it is this body, the Supreme Court of Kansas, that decides the meaning of that statute. And I'm not suggesting that the Attorney General has any procedural mechanism or should have any procedural ability to foreclose the agency from saying, no, the Attorney General is wrong. The statute doesn't mean X, it means Y.
That's what they're doing in Massachusetts. They're saying that the law permits their legal position. You're saying it doesn't, but then you're also saying she doesn't get to speak it.
She can, in her private capacity, she could file an amicus brief and say, I think this is what it means. But in terms of the state entering litigation, she's entering as a fellow plaintiff, as a party representing the state of Kansas.
In her official capacity as governor is exactly what it says. There are other parties where the state is the entity, but in her instance and Bashir's and Shapiro, they're there in their official capacity of governor.
The Attorney General shall appear for the state in all federal courts, 75-702, and when appearing shall control the state's prosecution or defense.
Do you think that when a governor represents that they are attempting to appear in their official capacity, that that's no different than a governor attempting to represent the state over which they're governor?
I agree with that, Your Honor. When the governor says, I'm here in my official capacity as governor, she is representing the state. And that's exactly what she's doing in this proceeding. But if she
would you take the same logic to a secretary, a cabinet level secretary? So when a cabinet level secretary says, I am here in court in my official capacity as the secretary of KDHE, is that person also representing the state?
Almost certainly. I don't know if you're talking about joining plaintiffs.
Just in whatever.
Like the Massachusetts.
I'm not sure it matters.
Yeah, right. Yeah, that's all. That person's also attempting to represent the state.
So your argument, if I'm following correctly, is that the Attorney General has the constitutional and statutory authority to override or to take over that litigation.
Yes. When so appearing, shall control the state's prosecution or defense. I think it is.
So again, this is sort of similar to my questions I had with your opposing counsel. Like I thought I understood where you were, and now I'm a little less certain. Because I thought at the outset you said you're fine with the governor representing herself in her official capacity. You're fine with the governor representing the executive agencies she has authority over. But now it sounds like you're not.
No, I don't think I said exactly that. I said I'm fine with her representing her office and the powers of her office. So like in this case where it is.
How would you do that other than appearing as the governor in her official capacity?
If the subject matter of the case was, does the governor have the authority to do X or have the authority?
So that gets back to my earlier question, which is, it seems like both parties are asking this court to adopt a standard which requires us to do an analysis of the substantive claims.
Yes.
That was my earlier question.
Yeah, and on reflection, I think you're right. You would have to address at least what exactly is the governor's office claiming.
From my perspective, at least, and that presents a judicially unmanageable standard. Whereas if we simply ask the more simple question, who is the client? That strikes me as a much more manageable standard. Do you have any response to that? I mean, because typically courts desire
Mhm.
to avoid judicially unmanageable standards.
I think your direction sounds correct, Your Honor, to look at the client if you're going to draw a line in this opinion, that might be a line you want to draw. But I would just caution or add a caveat that just because you've identified the client and then all of a sudden the governor's office is representing that client's interests, suddenly it becomes representing the state de facto. And that's why I think the position they're taking, their theory is a parallel litigation theory. The governor can sometimes get into cases and litigate on behalf of the governor's interests. And I'm not sure how broadly it is now, but the governor's interests. The attorney general clearly has the ability to jump into that same litigation on behalf of the state on the opposite side, which is exactly what we're seeing in the matter. We didn't intervene, but we filed an amicus brief on the opposite side. And I think that becomes very difficult to judicially manage. Let's suppose that we had intervened and we were a party along with the defendants in that Massachusetts case. Okay, now how does the court decide what the interests of Kansas?
Let me
You've
ask
got
a
two
simple
representatives.
question. This case right here might be a great example of this.
Okay,
Is the state of Kansas a party in this case?
I think technically no.
No. We have two subdivisions
Right.
of the state that disagree with one another over various important legal issues. And that seems to me to happen all the time. The state of Kansas is not always, in fact, probably most of the time, if we exclude criminal law, is not a party in these kinds of disputes.
Oh, I'd quibble with you on criminal law. I think the state is always a party.
That's why I said excluding.
Oh, excluding. Okay, gotcha.
Yes, obviously the state is always the party in a criminal context.
Yeah, that might be right, Your Honor. But let me go on to the judicially unmanageable things I was thinking about. So let's say the state intervenes, and if the opposing counsel gets what the governor is seeking, and that is ability to enter cases all over the country on behalf of the executive interests, whatever that means, you're going to have the governor of Kansas on one side, you're going to have the attorney general of Kansas on the other, and the court's going to have to decide. The attorney general says the interest of Kansas is A. The governor says the interest of Kansas is B. Which one is the compelling government interest to be assessed?
The governor cited in her brief and in her reply brief the case of Berger versus North Carolina
Yeah.
State Conference of the NAACP, and I noticed that that you didn't address that at all. But isn't that case stand for the proposition that courts can proceed when state law authorizes multiple officials to represent different, the state's interest in litigation, and that federal courts can't second guess a sovereign's internal allocation of authority?
Yeah, I disagree, Your Honor. There are two important distinctions in the Berger case. The context is important too. The context was it was a state photo ID law. The governor didn't like the law and in fact vetoed it. The state board of elections didn't like the law and they're appointees of the governor. And the attorney general didn't like the law. All of them publicly saying they don't like it. The legislature passes, governor vetoes, legislature overrides the veto. Then the law is challenged in court. The attorney general, who doesn't like the law, is defending the board of elections, the defendant, who also doesn't like the law. The legislature said, using the standards of intervention, we don't think our interests are being adequately represented here because these parties that are purporting to defend the law won't defend it. And so they were coming in on the same side using the standards of intervention because in those facts of that case, the attorney general and the board of education's commitment to fully defending the law was in question.
How is that different from what's going on here?
I'm not sure I understand how. Perhaps you could tell me how you think it's the same. And then
Okay, the legislature had a different position than the attorney general. Two branches of government.
In
Berger
in
said yes.
702 or right
Berger
in that
said
case.
yes. I'm responding to what you said about how it would be chaotic.
Well, it's not chaotic in that case because you had all of the entities of North Carolina all on one side. And they were on the same side in the case. They were all defending the state statute. Everybody was. But the legislature said, we don't believe the attorney general is going to defend it faithfully, and we don't believe the board of elections.
Here's a quote. When state law authorized more than one official to participate on the state's behalf, courts must respect the allocation even if it results in multiple state actors advancing different perspectives.
Different perspectives on the same side of the case. They were not on opposite sides of the case. They were all saying that the photo ID law must stand, but they were advancing different arguments as to why it should stand. They were all fellow defendants in the case.
Well, I understood it to say that the legislature was defending the law.
Right. The legislature was defending law, as was the Board of Elections, as was, the law had just been passed over the governor's veto. Private entity sues, the NAACP sues, and the Board of Elections and the Attorney General representing the Board of Elections are defending the law. The legislature says, you guys don't like this law. We don't think you're going to adequately represent the defense of the law. So we are stepping in, intervening, using the standards of intervention, which the court is familiar with. And under those standards, we can step in with you and all of us can represent.
So so different perspectives.
Different perspectives on the same side.
But why does that matter whether it's on the same side? I mean,
Well, different perspectives means different arguments. There are 10 arguments in favor of the law and the legislature comes in and adds 1, 2, and 3.
right, but the issue is whether or not they both can participate, the legislature and the attorney general. And the court said, yes, if state law says it's okay.
Right. And I think the court had to defer to state law as well. And they said, under the standards of intervention, this qualifies. The state law seems to also allow them to come in on the same side as the attorney general and the Board of Elections. So we're going to allow it. Remember, the question was, is intervention permissible? And the court said, yes, intervention is permissible under those circumstances.
I'm still hung up on the arguments that you're making in Massachusetts, that you filed this amicus brief in the middle of August. I don't understand why, if the governor's participation in that Massachusetts case is a usurpation of your authority as attorney general, why you aren't in a Kansas courtroom the day after you file the amicus brief going, that governor is intruding in an area that I have sole authority on. I have control over, pursuant to the statute. I like that because in my mind, it's still cleaner. It puts the issues directly, instead of an amicus brief that's in front of a different, it's almost like you don't want an answer from a Kansas court. But that would be binding, but you want to play in Massachusetts with these issues. It doesn't make any sense to me.
I see exactly what you're at. I see exactly what you're asking, Your Honor. And you are absolutely right. It's cleaner if we had brought a quo warranto action in Kansas court. For us, it was primarily a question of speed. There was a preliminary injunction already sought, and we wanted to notify the court as quickly as possible in Massachusetts that, hey, this new plaintiff doesn't represent the state of Kansas. We do. And we don't agree with the position being taken. And so it was merely a matter of speed. We reckoned that.
Well, you get to do it there, but
I suppose we could have done it simultaneously.
you can do it several places maybe,
Yeah,
but
no, I think, in retrospect, Your Honor.
place it's definitive, that defines what the Kansas Constitution means, what defines what statutes mean,
It's right here.
is Kansas courtroom.
Yeah, and ultimately it's right here. No, Your Honor, I think looking back, we probably could have and maybe should have done both at the same time.
So maybe to assuage my actual controversy problem.
Okay.
Based on what you've said in your letters and what they're citing to, if the appeals board in that SNAP case gives an adverse ruling to the governor, are you telling us that you are going to stand in the courthouse doors to block the governor from being able to seek judicial review of that adverse decision from that appeals board?
Yeah, we have been discussing that within our office because it's going to happen. It's quite clear the governor is going to lose in that appeal. And we have already taken the position that the governor was acting contrary to Kansas law when she refused to provide the names of the SNAP recipients in Kansas, which is all that was being sought. And so names and addresses, and identifiers. And so we believe that the position she's taken is in violation of Kansas law.
If we have an actual controversy, are you going to impede her ability to seek judicial review based on these legal theories that you're giving us?
We haven't talked through all of the options. One might be to allow the governor to employ her own counsel to pursue it. We've already taken the position in our agency that her actions violate Kansas law. So it would be hard for us to represent.
Then how can this dispute be right? If you're still leaving yourself with an exit strategy on the authority that you say you alone have, how does this come to us in a real fight? As opposed to a couple of elected officials who have a disagreement rhetorically and would sure like to have somebody point to one or the other as a winner.
Your Honor, there is definitely a live controversy, but I agree with you that there are ripeness problems in this case.
For legal purposes, for actual controversy purposes, where is there a live controversy other than a difference of legal opinion as to who gets to do what?
It depends on how you define live controversy, of course, but I believe the opposing counsel could argue that the controversy became live when the Attorney General's office refused to join the litigation. They could also argue it became live when the Attorney General took a position opposing the governor in an amicus brief. And so you have presented to another court two different positions of the state of Kansas, representatives of the state of Kansas, and that at that point there is a live real controversy.
And my problem with the amicus brief maneuver is that another judge has got that. So to me, that seems like an adequate remedy at law. I still get back to how, aren't we being asked to give advisory opinions?
Well, yes, in a certain sense, but on the same, if we had done what you suggest, Your Honor, and just gone straight to a quo warranto action to this court,
then we don't have this problem.
right? So
This thing is, you brought it. This governor is usurping my power. Please decide it. By what authority does she file that action in Massachusetts?
I agree. It's cleaner if it were done that way.
Who brought this action?
This was brought by the governor, Your Honor.
Okay, that's what I thought.
So I believe your colleague's point is if we had brought this action, it would change the posture different quite a bit.
And so given that you're the respondent in this action, what's your position with respect to whether it presents a true quo warranto action and or is ripe? Do you have a position?
We concede that ripeness is not clear, but we think it is ripe enough because you do have, as I mentioned, we do have these actions in other courts, and you do have a decision formally made by my office to decline the governor, and you do have a very well crystallized conflict on what the Constitution means and what the statutes mean. So you do have.
And how would the ripeness analysis change if it was your office that had filed this action as opposed to the governor's office?
That's a good question, Your Honor. Everything else will be the same.
You'd have not your brief. You have an amended complaint where she's trying to do what you say she can't do. Now she's doing it. Here, the argument is over what you might do if she goes forward. And you were pretty firm earlier in your documents, and now you're telling me, we may let her do that. Well, if you may let her do that, maybe we don't have a fight.
Oh, are you talking about as far as appealing judicially we don't think she has any legal basis for
I
doing so.
understand that, but if you're saying you might let her make the argument anyway,
we haven't done.
She has a complaint.
We haven't done all of the legal research to determine if she, what ways in which she might be able to defend her, because ultimately there's a question of federal law, right? There's a question of state law. There's a question of federal law. We think she's dead wrong, and we are not seeking to prevent any court from answering that question. But as to the interplay here about whether it changes when another party brings it, I think it's effectively the same. All the briefs are the same. Everything's the same. And so we might be we're being very formalistic, but maybe that's what we have to do as lawyers, and to say that there's ripeness in one posture and no ripeness in the other posture. Well, let me end where I began, and that is to simply reiterate that if this court does get to the constitutionality of 75-702, this court has already defined supreme executive power in Dawson, and it's at page 180 of 86 Can, and that settles the matter. And so 75-702 is clearly constitutional.
Thank you, Mr. Kobach. Any other questions, colleagues? Thank you.
Thank you.
Mr. McAllister, you're reserved 10 minutes.
While you're getting ready, Counselor, it sounds to me like you may be able to hire a lawyer and go make your.
That would be news to the governor, I think, not unwelcome news, but our point is she can do it anyway. So I would start with a couple of points. We're not saying that the governor wouldn't ask the attorney general to represent interests. She does, and she did. So he, in essence, may have a right of first refusal. There's no problem the governor has with that. The problem is when he refuses, as he often does, and it implicates things that are clearly within her purview, she needs the ability to retain counsel and pursue them on her own. And I want to go back to something Justice Stegall asked me early on. The attachments or the exhibits. Exhibit 3 is a letter he wrote to the governor. In the final paragraph is where the attorney general says, with respect to your closing threat to bring suit in your official capacity as governor, only the attorney general is authorized to engage the state in litigation, whether it be at state court or federal court. Should you proceed with another attempt to imprudently and unlawfully sue on behalf of the state, I will take all necessary actions in response to such a violation of Kansas law. Right. I think that goes both to ripeness, but also his view that her suing in her official capacity, which is what I heard him say, is the state. I mean, what kind of a remedy is it to say the governor can file an amicus brief as a private individual? I mean, that's ridiculous, frankly. Any of us, of course, can file an amicus brief as a private individual.
But this whole issue seems to be at least one of the crossroads of this case, the turning points in this case, is this idea of the governor in her official capacity being the state. And I asked your opposing counsel a few minutes ago, in this case, whether the state of Kansas was a party. I think the answer was no. Do you agree with that?
I agree that the state of
But
Kansas
the governor in her official capacity is a party in this case.
is a party, but she's not the state of Kansas.
Okay.
And
So that would seem to resolve this question about whether automatically, at least, a governor in his or her official capacity is representing the state. That's
right.
Not
and as I listened to the attorney general, I thought I heard him say, because we referenced her suing over interests of Kansas, she was somehow representing
right. It seems to me this rhetoric about interests is really confusing the legal issues.
And I think the governor could live with your proposal that this is about who's the client.
Yeah, because a lawyer can only represent the interests of his or her client, right?
Correct.
You can rhetorically say a whole lot of things, but at the end of the day, as a matter of law, you are only speaking on behalf of the interests of
your client. And again, the notion that if KDHE sues or DCEF sues or the Department of Ag sues, that is automatically the quote state of Kansas, that makes no sense. And it's not at all consistent with the statutes authorizing those entities to sue and be sued. I'd also say, at one point I thought I heard the attorney general say he agreed the governor could perhaps sue in her official capacity. But of course, even if that's what he said, it's belied by his own actions and by the things he said in written communications to her. This is not about 1861 and there being only an attorney general. The attorney general is not here telling the governor he can't represent her because I don't have enough attorneys. So now you can hire somebody. He's got plenty of attorneys. He's telling her, I won't represent you because I don't like the position you want to take. So I don't think the resources have anything to do with it. The language of the statute was pointed out is pretty clear. It talks about a state interest being affected in any way. It's not limited to a conflict of interest, as lawyers would know that, and it would be redundant today anyway, because the rules of ethics would prohibit representation in those circumstances.
Well, and if the attorney general doesn't believe in the merits of the argument, then they have an ethical duty to step aside because they can't give zealous representation.
Sure. I mean, and so that's, again, he has the right of first refusal. He can say, I don't like the case. I'm not going to pursue it. But that does not mean the governor cannot then have her own counsel and sue in her own official capacity to protect the interests of her clients, if you will, the agencies. And that's all she's trying to do here. So, he can have that view, as wrong as it may be, given that in both federal cases we've talked about, relief has been granted. It might ultimately get reversed, but it's pretty hard to say it's frivolous when a federal judge says you win. So again, the notion.
Would you agree that in that case, hypothetically, the Attorney General could seek to intervene purporting to represent Kansas and take a position contrary to the governor in her official capacity?
Absolutely. And I completely disagree with his effort to characterize Berger. I don't think the Supreme Court, it didn't matter that they were technically all defendants. They were speaking with different voices. I mean, the federal courts have dealt with this. Perhaps this court has dealt with it, but certainly the federal courts have dealt with it. When the Attorney General sues the Kansas Department of Revenue, you have two state actors speaking with very different voices, and the courts don't say, well, we can't deal with this because only one of you can really be state interest. So Berger is not limited in that fashion. It was simply the recognition that many, if not most states, have divided executives. They often have other kinds of powers. They may let certain entities sue that might not sue under the federal system. And the Supreme Court was saying, look, if the state authorizes it, we'll hear their voice. That's what Berger stands for. And our position is here, state law authorizes the governor to speak in litigation. That's all she's ultimately really trying to do. And I go back to Justice Biles. I think you're right on when you characterize, or at least asked, is the Attorney General saying he alone gets to decide? That's exactly the position he's ultimately taking, because he's saying anything apparently is within the interests of Kansas. Therefore, it's the state of Kansas. Therefore, it's him and him alone. And I'm also a little surprised to hear him concede that the legislature could take away all his power. I would argue differently were I in that role. But that's our point with the governor. The legislature can't take away the power that she is constitutionally granted.
Having heard all the arguments that we've gone through, I'd like to circle back to Justice Biles' comment that this is a rhetorical disagreement, there's no live controversy, and it would be an advisory opinion. Can you speak to his concerns?
Well, again, I'm not sure what more we need to do to crystallize the dispute. The Attorney General, I think, agrees with this. I respectfully don't see what difference it would make if he filed a quo warranto action in state court. To do what? To get an opinion on who has the power.
Decide whether the governor had the authority to participate in that Massachusetts lawsuit. That's an act. Does she have the authority to do that?
But that's
clean.
What we're here arguing.
Clean when it's an amicus brief in front of another judge, so you got an adequate remedy at law kind of problem. And then when I try to narrow it down to the impending threat or something I can get my head around, the Attorney General says, well, we may let her do that.
Well, that's news to us, but also
that's kind of the same problem Shawnee County had.
But again, respectfully, Your Honor, so if he filed this suit, it's right, but because we filed it, it's not. And I just don't see.
And I think it is the issue that if the Attorney General filed it, it would be, that the governor was interfering. It's your position, from your briefs anyway, is that the Attorney General is interfering with her ability to represent the interests of her office.
Yes.
And as concrete example of that is the amicus brief, the motion to dismiss that was filed. And so is it your position that that is what makes it a live controversy?
That should be more than enough to make it live. And we've also got very clear promises, in spite of what he says today, that if you try to file anything else in your official capacity as governor, I'll do everything.
But that's
within
not
my
really a
power.
live controversy. at
That
this
is not,
point.
I agree,
But
but
the fact that there have been legal positions taken in public by an amicus brief and a motion to dismiss, that's not a threat. I mean, that's actual, that happened, right?
yes. And I think he would view it
How
as.
so, I guess, because I thought you're saying the state I mean, the AG can represent the state in these proceedings. So when they do just that, that's not preventing from the governor from filing in her official capacity.
No, but the difference, Your Honor, is he's not just coming in and saying, here's the interests of Kansas. He's saying, I'm the only one that can speak here. The governor has no legal capacity to speak in this lawsuit. And I would bet a lot of money if he filed something and the governor or someone else came in and said, the attorney general has no power to be in this lawsuit. He would view that as interfering with his ability to litigate. Now, the governor comes in and says, I have a different view. That's essentially an amicus.
But in the DMAS, I can't remember the names of everything, but in the DMAS suit, didn't he ask the court to dismiss her as a party?
Done that at least one of the cases. Yes, actually wants her out of the case. And
Right.
so that's our,
yeah.
he's not
just
just,
stating a different position.
he's not coming
I'm
in.
not the only one that can speak. And, I read the brief and that's what he said. And so she
Right.
can't be a part of this.
Right. So he's not just saying, I read this Kansas statutes differently than the
Right.
governor about whether the data has to be turned over. He's saying she can't be.
Well, would you concede that it is possible, hypothetically, in cases that the governor of any state in his or her official capacity would not have standing? Just depends on what's the subject of the lawsuit, right?
Absolutely.
So
Absolutely.
I don't see anything particularly nefarious about a different party saying this party over here doesn't have standing.
Well, except it's not standing in that she's not interested in the matter or she doesn't have some sort of concrete stake in the matter. She does. It's a different kind of argument that there's no legal
that she doesn't.
capacity for her
He doesn't have
to
the authority. the
file
legal
this
authority.
suit. So I would not disagree with you if he came in and said, look, she's not shown any injury to any interest of hers. She should be dismissed for lack of standing. You could say that about any party.
Right.
But that's not what he's arguing.
On this reference, and I've probably gotten lost in all the papers and everything, but this reference to a motion to dismiss, that's just the request that the Attorney General made as an amicus in the Massachusetts lawsuit that said the court ought to dismiss it. And my immediate question was, it's been a long time since I was around a federal court, but I didn't know amicus got to file motions.
They generally don't. Would be my understanding.
So again, trying to figure out if this is an actual controversy, that's not a major intrusion, it seems to me, into.
Well, so, but I think if the district court there said, well, look, you're an amicus, you can't, I mean, he could easily just seek to intervene and then make the exact same motion. And of course, what the governor faces is anytime she files, he could do exactly that. And he has done that, actually intervene and take a different position. He's intervened in cases and kicked executive agencies out of those cases, essentially. So he's definitely done that.
But again, getting back to my problem, is it really that big of a deal? I mean, I don't understand how we can have a quo warranto action that says the Attorney General made a bad legal argument, shouldn't be able to make that legal argument.
Well, I think
That gets sorted out.
that is part of what we want, and only this court can ultimately decide that that's an invalid legal argument. But again, I come back to it's a unique kind of legal argument. It's not standing, it's not merits. It's she doesn't have the power, kick her out. I'm the only one who can speak there. So if this is going to go on and on every time she files something, I'm sure he would consider that an intrusion and a usurpation if other state officials came in every time he filed something and said he shouldn't have power, he doesn't have power to do this. She just wants to be able to express her view without that kind of obstruction, but acknowledges he's entitled to express his own views on the merits. But we don't argue against that. Unless the court has further questions.
Any other questions, Paul? Thank you very much, and thank you very much, both parties, for your arguments this morning. We will take this matter under advisement